Hi, my name's Attorney Ed Malek, and again, it's my opportunity and my pleasure of talking to you briefly today. I have a very fairly short range of time, so I'm going to be fairly brief in my comments. It's about the concept of legal concept of Robinson v. Bates. Now, most people haven't ever heard of the name of it's a case name, Robinson v. Bates, have ever heard of it, but it's profoundly going to affect any settlement you have or any jury trial that your attorney might get involved in on your behalf, uh, to and it will affect the ultimate result, or may affect the ultimate result of your case. Robinson v. Bates came up in a slip and fall case, a homeowner's slip and fall case, and it was not really um, a necessary decision to the case itself. It was totally brought out by the Supreme Court, brought it forth, and it was dicta. Dicta is something that was not necessary to the decision of the case, but it became a general rule in Ohio, and the insurance companies are loving it. You and I and attorneys and the people should hate it. Robinson v. Bates specifically says the insurance company can introduce the medical bills that were paid by your insurance company at the diminished amount. In other words, when you go to a hospital, your bill may be $40,000, the hospital normal hospital charges, but Medicaid, Medicare, or alternatively health insurance may diminish that amount to, say, this is an example, $8,000 to $10,000. So before a jury, or in their discussions, settlement discussions with you, the insurance company says, well, the bills are only $8,000 to $10,000, when in reality, the bills may have been $40,000, $50,000 or more. And they're going to say, it couldn't have been a bad injury. $8,000 worth of bills, we'll offer you $2,000, basically, or $3,000 or $4,000 above the bills. They use it to diminish the value of your case, and it bears no real relationship to the value of the case, because your value of case, the time you spent in the hospital, the time you sent for these extra texts, may total $30,000 or $40,000, should measure the pain and the quality of life, loss of quality of life that you went to, and the pain you've experienced and the pain your family experienced. But no, they diminish it to the amount that the insurance company actually pays. Now, they can bring it forth in a jury trial as well. Before, we could bring back, the attorneys could bring back the entire bill to demonstrate how much suffering, how much pain this person endured at the hospital for 2 days, 3 days, 1 day. And now they bring forth only the amount that the insurance company paid for. In Medicare's instance, it's pennies on the dollar. Medicaid is a little bit more substantial. Health insurance depends on the policy, and they pay maybe a third or fourth of the bill. But these are the bills that are introduced by. Now, you can introduce your own bill later on. Your attorney will do that. But when you present, and your attorney, you should have a good attorney that talks about the quality of life, your quality of life, the quality of life for yourself, your family, your loss of income, your loss of enjoyment, the grandkids, your loss of not being able to bowl, your loss of not being able to shake your right hand because your right hand was injured, for instance. These are quality of life issues. And I'm really upset about the Robinson v. Bates law, but it pervades in Ohio. We are a very conservative court, and it pervades in Ohio. And unfortunately, the conservative branches and the insurance companies brought this forth and stuck us individuals with it. And as attorneys representing people who I care avidly for, I'm really upset. So anyways, I hope you are too. And remember when you vote, by the way. But come to Malek and Malek, and we'll give you the right answers. And we'll be honest, and we're sincere, and we care about people. And if you don't come to us, come to attorney. If it's a grievous injury, it's a really bad injury, you have to have an attorney. Now, if it's something less, sometimes we'll advise a person to go ahead and settle with the insurance company if it's very minor. We try to treat people as we want to be treated, as fellow human beings, and it's our civic duty besides our legal duty, ethical duty. Thank you very much, and I look forward to talking to you sometime other time in the future. God bless.